Custody is almost always the most challenging part of a divorce. There are two types of custody, and you need to understand them if you don't live with the other parent or are thinking about separating. I'm Jenny Bradley, owner of Triangle Smart Divorce in Cary, North Carolina. Like I said, there are two types of custody, not only in North Carolina, but across the country: legal custody and physical custody. First is legal custody. Having legal custody of your children means you have the right to make decisions about their welfare, such as educational decisions, religious decisions, and medical decisions. Legal custody applies to major life decisions. Courts typically prefer for both parents to participate in making major life decisions together. This arrangement is called joint legal custody. But there are situations where a judge might grant one parent sole legal custody. This might happen if the other parent lives a significant distance away, is abuseful or neglectful, or isn't involved in the day-to-day life of the child. If you are granted sole legal custody, you do not need agreement from the other parent to make major decisions. The second type of custody, physical custody, refers to where children live on a regular basis. Once again, courts prefer shared physical custody, but that does not mean the child splits their time 50-50. Parents with shared physical custody can come up with a schedule that works for them. Shared physical custody just means the child spends a substantial amount of time living with both parents. If one parent has a child the majority of the time, they might be granted primary custody. In that situation, the other parent has what's referred to as secondary custody or visitation. That typically consists of specific periods of custodial time during the week, as well as a portion of the holidays and vacation time. With both legal and physical custody, you have two paths for resolution. You either work it out with the other parent or bring it to court and have a judge decide for you based on their interpretation of what's best for your kids. And you might not like the judge's decision. If there are extenuating circumstances, it's absolutely worth it to fight for sole legal custody of your kids. But in many cases, we find the best thing you can do is work together so you have input on decisions about your children. Likewise, sometimes you need to fight for restrictions or limits on the other parent's custodial time. An agreement just can't be reached. In these situations, court may be the best option for your children, even under the best circumstances. Divorce is hard on kids. But you can make it easier on them by making sure custody decisions are made by focusing on them and what's best for them. At Triangle Smart Divorce, we believe in trying to make sure the kids have regular contact with both parents, if appropriate. Lastly, it is important to understand how a custody decision can affect you later. An experienced family lawyer will be able to help you see the big picture and help you figure out what's the best possible custody outcome for you, and more importantly, your children. Triangle Smart Divorce is here to help you, so give us a call.